My lords, we also have another authority in the case of also black, my lord. My lord, once the law does not allow, provides for, then a person cannot appeal against such a particular issue. The law must provide a right of appeal. My lord, this appeal is premised on an intellectual kind of ruling, the bail.
Don't use words kind of.
Most obliged, my lords. It is premised on a bail application that was declined, and that, in our view, is intellectual in nature. Why we say so is that it has no bearing on the final.
There is no decision, because the Constitution talks of a decision. Are you saying there is no decision to be appealed against?
My lord, it is a decision.
There is a decision.
That is true. There is a decision, but the decision has no bearing on the final, on the final hearing of this matter, my lord.
What is that? That it has no bearing? I don't understand. Are you saying it was an interlocutory matter, and therefore you cannot appeal against it?
That is true, my lord.
Yeah.
That is true, my lord. It's an intellectual matter, my lord. That cannot be appealed
My
against.
words when you have not recited on them. So where is that found in law?
My lord, that was interpreted in case law. It was interpreted in case law. My lord, the interpretation from this is that there must be that the right of appeal must be provided for expressly in the law. My lord, I can read it comfortably.
You have already read it. Just interpret it.
My lord, this section gives a right of appeal only where a final decision has been taken by a High Court judge in excess of their original jurisdiction. Yes, my lord, says from a conviction or a sentence. So meaning if most obliged, my lord. So my lord, unless there is a conviction and a sentence, no person can appeal against any other decision in the High Court.
Why has it taken you so long to use the word which are written? Is that all?
My lord, I don't know, I can answer it. My lord, I thought I would give some other explanation before I reach that. I was going to say it, my lords. My lords, therefore, since the appellants are not convicts, nor were they sentenced, they have no right of appeal in this regard. Their remedy is in reapplying for bail, but not to appeal against it. My lord, that we are fortified in that respect. We are fortified with a decision in the case of Charles Harry Ssewanyana versus Uganda. Yes, my lord. Charles Harry Ssewanyana versus Uganda. And my lord, it's attached on our submissions. It's attached on our submissions. Yes, my lord. It is a criminal appeal number 027 of 2005. It's the Supreme Court decision, my lords. My lords, in that case, your senior colleagues in the Supreme Court, the Land brothers and sisters, my lord, most obliged, most obliged, my lords, in that case, it was held that there is no appeal that can lie on an interlocutory order unless it is a conviction or a sentence. And my lords, allow me to just say this. It is in that respect that we picked the two quotations, my lords. Allow us just read them verbatim.
Please do.
My lords, it was held that it is conceivable for an accused to launch appeals against every interlocutory order made during the trial, which he or she perceives, even incorrectly, to be wrong, and thereby render a trial prolonged on frivolous points by appealing on every point of objection. My lords, allow us.
You're saying that this is frivolous. What is before us is frivolous?
Absolutely, my lords. Allow us, my lords, to read the next quotation, my lord. It is page 3 of our submissions.
From the case.
From the case.
Yeah.
I do, my lords.
I'm not sure whether you make the request to amend the case and also the was filed, whether you have a ban of authority. So that we follow it
to release the submission. Behind this submission, you see.
We are just thinking that it's talking property, so we
They didn't serve you.
No, it wasn't attached on our.
Can you give counsel a copy so that he follows what you are saying? Give me my copy.
My lord, we serve everything.
And also serve Mr. Waka with the copy you have not served. Okay, you can proceed with your submission.
Most obliged, my lords. My lords, another quotation is the
point.
Yes, my lord. That's why we beg before you.
Kabane mulayo wakankana waka zero mulabi
My lord, just about 30 seconds.
ndowooza mulaba ono munyampi ono muwali wa gavumenti agamba ku Ssegirinya basigaleeyo, ono gwe mulaba wano kwenu balo bakankana nabo bakankana. Ssegirinya wayomba.
Yes, my lord. Most obliged, my lord. Most obliged.
Bitali prepared.
Prepare yourself, but these people are saying you should have notified and fight. But go ahead with your submission and complete within the next 5 minutes.
Most obliged, my lords. My lords, allow us quote one last quotation in that respect. It was also said that the growing deplorable practice.
At which page?
My lords, page 3 of our submissions. Most obliged, my lord.
Put your submissions. They're not quoted.
My lords, the we misplaced our submission, our authority here, my lord, that we can't read the exact page where it was. But most obliged, my lord. Most obliged, my lord. Most obliged, my lord. My lord, allow us just cite one more last authority. That is the case of Makumbi Moses. Makumbi Moses versus Uganda. It is a criminal appeal number 202 of 2020. And criminal application number CP 167 of 2020. Yes, my lord. So attack. My lord, in that case, it was held that, my lords, from the authority that we furnished court, we refer to page 5. Page 5 of that authority. My lords, allow us quote exactly that was held in that case on that page. It was held that the operative words from the above provision are convicted and sentenced.
Conviction and a sentence.
Yes, my lord. Section 132(1) of the Trial of Indictments Act above is crystal clear that the only right of appeal conferred upon an accused person is in respect of conviction and sentence by the High Court in the exercise of its original jurisdiction. In excess of its original jurisdiction. A conviction and sentence presuppose that there has been a full trial by the High Court and a final order made. No right of appeal is conferred upon an accused person aggrieved by a High Court order relating to bail or any other interlocutory order in criminal matters.
Okay, that point is made.
Most obliged, my lord. And in that case, my lord, the appeal was dismissed. My lord, in the circumstances, we invite this court to maintain the same decision because this was a court of appeal decision, my lord, a decision of this court. And the facts are almost similar. It was in relation to bail. We invite this court to invoke that decision and have this application dismissed on a plenary point of view, my lord, in order to avoid wastage of time as it diverges into the next admits of the appeal. We so pray, my lords.
Thank you.
I'll be very, very brief in the response.
Hold on, brother.
Before you sit down,
Yes, my lords.
you are saying that this is a matter of the High Court. And that the bail application should have been made in the High Court. Are you averse to having this bail application agreed on terms with the High Court? Do you oppose an application to the High Court if it's made?
My lord,
Because you are using a point of law and what is the position of the state about the bail of these
my lord, the circumstance under we submitted like that was to give a remedy. What would be the remedy? Instead of an appeal,
Yes.
what remedy is available?
Yes,
There-
there are some people who are in prison. Would the state be adverse to having them released on bail?
Especially when you know that they have been in prison for a long time. How long have they been in prison?
My lord, about 8 months.
9.
How long?
200 days.
9 months, my lord.
9 months. 9 months, and they were here. Yes, the law is here. We have to look at it. We have to follow the law. But the practical aspect is that 9 months. Why aren't you prosecuting these people? What is the problem?
Also, obliged, my lords.
No, answer that question.
My lords, as the prosecution, we committed the accused persons to High Court, and therefore it is incumbent on the High Court to have the matter cause listed and fixed for hearing.
So the prosecution is ready to actually proceed.
Absolutely, my lords.
You are ready? Even when we give directions that this matter should be heard immediately, you are ready to proceed.
My lord, we are.
This is a serious issue. People have been in prison for 9 months. They were released on bail at one time, then were rearrested. Charges are grave, treason and murder and so on. There should be a trial. They are members of parliament. Now their constituencies are not represented. You see the effect of delay? And you now come here with the technicalities. You read the law very carefully and you're using technicalities to make sure that they remain in prison. But the trial should be there. That's the only way justice can be attained. Okay, you're finished. I'm sure you have had. Mr. Wakafu.
My lords, I'll be very brief. My learned colleague seems to be telling this court that bail is an intellectual proceeding. In my opinion, it is not an intellectual proceeding. It is a substantive proceeding on its own, because it is a proceeding which is meant to preserve the right pending trial, the right to liberty pending trial. The law is recognized in our constitution. My land colleagues are quoting the sect of Shabas Attorney General, which is embedded in the 1967 Constitution. That Constitution, my lord, is very different from the current Constitution we have. The current Constitution clearly spells out bail as a right, and the right to liberty, under what circumstances can be lost and so on and so forth.
Yes,
So my lord, it is,
why you are now talking and the press are watching.
yes, my lord,
The right is to apply.
the right is to
Does
apply.
not grant. The right is to apply for bail under the Constitution,
Yes, my lord.
but it is not grant. The granting is at the discretion of court.
My lord, that is not true. The discretion of court was spelled out in Article 22, Clause 5 of the 1967 Constitution. The current Constitution doesn't say so. You must give valid reasons for refusing a person bail.
That is what it is.
Yes, the bail can be refused, yes, but the court under Article 22 is supposed to enforce a person's liberty, but with good grounds, bail can be rejected, can be refused. So, my lords, the problem we are having today is that we lived so long with one constitution for many years, and this new constitution we still keep bringing the jurisprudence of the past until today. So my lords, bail is a right under Article 23, and Article 50 of the Constitution empowers the competent court to enforce that right. So the competent court in this case was the High Court.
Can I interrupt you?
Yes, my lord.
This objection is not on the right to bail what the Constitution says. It says the appeal is not grounded in the law. There is no law that allows you to appeal. Am I saying so?
My lord,
Why don't you answer that?
I'm answering it, my lord. Under Article 50 of the Constitution, the right to liberty is one of those.
Not the report? Is it?
No, it's one of those rights which are guaranteed in the Constitution, supposed to be enforced under Article 50. Article 50 says these rights shall be enforced under a competent court. Now the competent court in this case was the High Court, but under the Human Rights Enforcement Act of 2019, Section 16, it states that there is a right of appeal when any of those rights under the Enforcement Act. My lord, I'm sorry, but
Did you give us a section of the Human Rights Enforcement Act?
I said Section 16, my lord. It says a person agrees with the decision or order of a competent court. Now the competent court is the one talked about in Article 50 of the Constitution. May, in the case of the decisions or orders of a magistrate, or appeal to the High Court. In the case of the decisions or orders of the High Court, appeal to the Court of Appeal. That is clause 1C. So, my lord, we are rightly before you. This court has a right to proceed. And I'm sure the case of Makumbi was decided before the Human Rights Enforcement Act was enacted in 2019. So, my lords,
What is the correct citation? Is it the Fundamental Rights and Freedoms Enforcement Act?
the citation, my lords, is the Human Rights Enforcement Act 2019.
This decision is August 2021.
Yes, my lords, but it might be punctilium. They may not have looked at the relevant laws, my lord.
Yes, continue,
So, my lords, we are right before you, and we are submitting that the High Court made an error in refusing to release the accused persons on bail. Particularly, my lords, the accused persons had been granted bail by another court. Now, when this matter goes to another justice, the justice did not take into account the fact that these people have been on bail, and therefore did not interrogate why they are coming back to the same court for bail. Failure to interrogate that matter led to an injustice, my lords. Because first of all, the judge of co-equal jurisdiction cannot stand on appeal. Cannot stand in appeal for a decision of of his or her brother. So in this case, Justice Ssewanyana was supposed to enforce the decision of Justice Eva, who had no. Victoria.
So he could not part from Justice Victoria.
My Lord,
This is an appeal.
So
I
my-
think you made your point is fine.
Yes. Are you through?
My Lord, that is my argument.
That's your argument.
That these people had been on bail, and
Yeah.
if Justice Ssewanyana had been interrogated why they were coming back to him, he would have gotten to know that these people were not even allowed to get out of the prison gates. They were kidnapped immediately after they got out of the prison gates.
Okay.
They were kidnapped and taken back to the same court. So my Lord,
Kidnapped or arrested?
my Lord, they were not arrested, my Lord. They were actually kidnapped. I don't know a better word than kidnap, abduction actually. Actually, they were abducted.
Okay.
So
Yes.
these people were abducted and taken back to the same court. My Lord, this was clearly meant to scatter.
I think Mr. Wakafusi, you have made your point.
Yes, my Lord.
You have made your point. Unless you have anything outside that,
My Lord, that's all, my Lord. I pray that this court is entitled under the Human Rights Enforcement Act to enforce the rights.
we have had that.
It is also a competent court. Yes, my Lord.
But you are saying that the judge of court jurisdiction,
Yes, my Lord.
local jurisdiction, are not overturned the decision of another judge. And at the same time, you brought me some facts saying she ought to have been the past. But I want to know exactly, are you dealing with the question of jurisdiction of this judge who refused bail? What are you dealing with?
My lords, the rest of the matter will be submitted upon by my learned colleague Guago.
Concerning that point,
Concerning this point, I'm saying that Justice Ssewanyana did not bother to interrogate why these people were back
But he had power to.
when he had power to. Under Article 22 of the Constitution, he was supposed to do so, to enforce their rights and ask himself why are these people back when they were granted bail. Then they would have explained what exactly happened. My lords, the affidavits in support of their bail before Justice Ssewanyana, they clearly showed that they had been abducted and taken back to the same court. My lords, this court, this matter of the Black Mamba, my lord, it happened when the security forces forcefully entered and scattered the right of court to grant bail at one time, and then it was termed as the discretion of the Temple of Justice. My lord, this time they did it in a very clever. They went to the prison instead of having them treated.
Okay, Mr. Wakafusi, that is now going further than the arguments you have made, which are very good arguments. You are now going into areas which are not in.
My lord,
The Black Mamba and so on. We have no facts of that before us, and we are going into all matters like that.
my lord, before you,
Yes.
I'm sure on the proceedings before you, you find a ruling of one justice having released those people on bail. Why were they again taken back to another court?
yes,
And what circumstances?
is there a question of jurisdiction? What you are saying, no, he has jurisdiction. So he could.
My lord,
Did he have jurisdiction?
to interrogate,
Did you have any jurisdiction? Did you know
Yeah,
what time?
a new application for bail.
That's what I was asking.
That's what he's asking.
he had the jurisdiction, my
New
lord.
of justice. Maybe give your colleagues a chance to speak.
Most of them, my lord.
Yes, Mr. Wakafusi.
My Lord, in addition to the submission made by my colleague, I wish to state that this court is
Is
sitting.
he more senior than you? Is he more senior than you.
Yes, my lord, is my senior.
I'm seeing that him though he's a sarongo.
Banange mugende ku YouTube mbasaba mugende ku YouTube tulira YouTube ke ayi mukulembeze official. We are live YouTube.
Article 134 of the Constitution creates that right. That is clause 2. An appeal shall lie in the Court of Appeal from such decisions of the High Court as may be prescribed by law. So that is the starting point. Where there are decisions made by the High Court, an appeal shall lie. Now, what does the law say? The law prescribes the procedure on how that appeal shall be preferred. I'll take you now, my lord, to the Criminal Procedure Code Act. Cap 116, particularly section 36. My lord, you look at two provisions, 35 and 36, to make an informed decision on this matter. 35 is about appeal against an acquittal or dismissal. That is 35. That's when the matter has been heard on merit and the decision is taken either to acquit or convict an accused person. But 2, this is where our case lies. Section 36 provides that power of the appellate court on appeals from other orders. And this is what it says. The appellate court may, on any appeal from any order other than a conviction, acquittal, or dismissal, alter or reverse the order. This in effect means appeals lie before this honorable court from other orders or decisions other than acquittal or dismissal. So the jurisdiction of this honorable court is not restricted to only acquittals or dismissals.
When you are dealing with an appeal under section 35, you can also deal with any other order which has been made.
Tugende ku YouTube.
The later statute, an earlier statute. When you look at the trial on investment act, the later statute, section 132, which seems to
Manuel.
Yeah, there is two statutes. What do you do? And there be an appeal where the matter has not proceeded to a conviction.
This is the back of that I was saying in my word, starting with Article 134, clause 2, coming to section 36 of the Criminal Procedure Code.
You have done very well.
Now I'm proceeding to the TIA. He read only section 132, but he not address you on section 133, which also falls under the same chapter. 133 of the TIA. Yes, the 134, 33 rather. Which also falls under the same chapter on appeals against High Court, appeals before this honorable court. And now it says appeal against special finding. May appeal against the finding to the Court of Appeal on a question of law or fact, or mixed law and fact, and the Court of Appeal shall allow the appeal if it thinks that the special finding should be set aside on the ground that it is unreasonable or cannot be supported having regard to the evidence, or wrong decision has in fact caused the miscarriage of justice, or on any other ground if the court is satisfied that there has been a miscarriage of justice, and in any other case shall dismiss the appeal. But the Court of Appeal shall, notwithstanding that it is of the opinion that the point raised in the appeal might be decided in favor of the appellant, dismiss the appeal if it considers no substantial miscarriage of justice has actually occurred. And we are saying
What is the special finding?
the peculiarity of the bail proceedings, which was, the case was made by my right friend. This is not an interlocutory matter. That's the point I'm substantiating. That the proceedings in regard to bail are special in nature for enforcement of rights. It's a creation or a creature of the Constitution, that the right to apply for bail, and the original proceedings. The right to apply for bail are separate proceedings. And these proceedings are initiated under Article 23 of the Constitution, and the court has a discretion to make a decision. Now, when court is making a discretion or renders a decision with material irregularity, then this honorable court has all the powers to intervene. A decision on bail cannot be taken to be interlocutory in nature. That is 1-2. It will be an absurdity for one to contend that a decision on bail at high court level is final. It's an absurdity, my lord. And he said the remedy lies in filing a fresh application. Suppose I file incessant applications and they are all dismissed, like it's the case with this matter. You file, you go back before the same judge, again he dismisses on the same grounds. Like in this particular case, the judge said, your special status as members of parliament clearly indicates that you are flight risk. You can always run away from this jurisdiction. How is he going to change his mind if we appear before him again? Because the file still will go before High Court. So would that curtail the jurisdiction of this honorable court? We are saying no, an appellate court can interfere in that matter. And again, my lord, to further buttress that particular argument, I take you to Rule 2 of your rules of procedure, the rules of this honorable court. And that Rule 2, my lord, is widely in nature. Rule 2, my lord, sub-rule 2 of Rule 2 of the rules of this honorable court. Notwithstanding these rules, nothing in these rules shall be taken to limit or otherwise affect the inherent power of the court or the High Court to make such orders as may be necessary for attaining the ends of justice or to prevent abuse of the process of any such court and that power shall such power shall of any such court.
You can see him.
and also my Lord, my grandparent, Shamin Malende. Malende.
Council, you should have given us notice. You should have given court notice. You should have given the other side notice that we are going to raise the PO. But since the Constitution says we do substantive justice, what is your PO about?
My Lord, before the substantiveness of the PO, would like to respond to the issue of notice, my Lord, with all due respect.
What do you want to respond to?
Before we respond to the substantiveness, my Lord, of the PO, would want to respond to your issue that we did give you notice.
You can see him.
We feel that this court allows us procedurally in response to whatever.
Yes, because I see what you really filed was very sketchy.
Yes, ma'am.
Now, when I look at the submission of Mr. Clark, they are filed jointly by the company advocate and the Wakaluzi and company, meaning that you are also part of the file.
My Lord, with your permission, I wish to put that disclaimer. You know, in practice, when you are doing instructions, actually we also joined Marina and company advocates, but that was exclusively for one law firm. So we would wish to proceed.
You are just confusing them without this authority.
We regret that, my Lord.
So these documents should not hold them.
We regret that, my Lord.
What do we do with this document? Which represents Rakabuza and he says I didn't find it.
This is why we are asking, my Lord, we proceed for that.
We disregard this submission.
We can make reference to that as
No. We have to get it correctly.
my Lord, the reason I have explained the reason we did that was for purposes of having something on record that we submit and we are caught up by time. We may be allowed to somehow adopt aspects of the same.
But you are hearing together at the bar. Why are you disowning each other? Are you in half of them? You don't seem the body language. You don't seem to be together.
My problem is that because of my poor mobility, it was difficult for me to find my colleagues and so that I could hold a joint meeting. So most of the things we are doing them on phone. Do this, do the other, and so on and so forth. So my lords, that document, whatever is there which is useful for our clients should not be left, should not be ignored. As long as it can be useful for our clients, my lords.
And
I think that's the best way to go. Rather than you disown it, Rakafuzi now has said it's okay, even if he did not endorse these submissions, he now accepts them that they are joint. Is that not so, Rakafuzi? So that then they can be used.
also blood prior.
So you suggest that
And
we
the
adapt
observation,
them?
I wanted to respond to the observation Myers made by the bench as to the.
Don't go to body language.
Yes,
We want to go ahead with the appeal. The appeal is before us. We want to go to those style statements.
Most of that.
Now we have submissions filed separately by Rakafuzi. Rakafuzi, you want them to be adapted?
Most of them, my lords.
Okay. Your submissions filed on 20th June are adapted and your submissions to be considered in this appeal.
My lords, can I submit now?
No, you are going to submit. And then, Mr. Rukwago, you have your joint submissions also. What do you want us to do with them?
My Lord, I pray that it be adopted. With additional submissions being made. With additional submissions being made for our Bible.
Yes.
Most of that.
So the submissions of the parties, joint submissions are also adapted for consideration by the court.
Most of them.
Now, you know the rules. When you file written submissions, then you don't have to go into a lot of detail.
Yes, my Lord.
It will be highlighted.
Yes,
Don't again take a long submission to oral. Because the ordinary shouldn't have this not make highlights. Can go ahead with that.
Yes, my Lord.
The respondents you acquired, they have adapted their submission. Do you have anything to say?
Yes, my lord, my lords. My name is Richard Vili Vumuka. I'm the Chief State Attorney. My lords, we also filed our submissions on the 1st of June 2022. And we also did it on our evolution, my lords, because the appellants had filed conferencing notes, which they served on us. And because we saw that time was running out compared to the time when the appeal hearing had been fixed, so we responded. But last week we served with on the 20th we served with submissions from the appellants, my lords, which you were actually about to struck out, my lord, because of disclaimers, but have been accepted. My lord, in that regard, we pray that court adopts our submissions, which were filed on the 1st of June 2022.
You don't have to adopt anything. So if you are putting your written submissions, you rely on them as your address to this court. Then we will consider them.
my lord, we prefer to have them accepted and then we also
Okay.
follow up with the oral submissions.
Okay, that's fine. We'll look at them, we'll take them into consideration.
My lord,
Yes.
we pray that they proceed with the highlight, with the order highlights.
You want to start?
Your Lordship, Joseph Chomhendo, Chief State Attorney. Your Lordship, we have, before my senior land colleague raises his points, we have a preliminary point of law which we believe could dispose of this appeal. And if it may so please you, would pray that we raise it first before they raise their issues.
Council, you should have given us notice. You should have given court notice. You should have given the other side notice that we are going to raise the PO. But since the Constitution says we do substantive justice, what is your PO about?
No, my lord, a charge arising out of the same series of events.
A different charge.
But earlier on, my lord, when you look at the record, they had amended the charge sheet. Because originally there was 6 counts, murder and attempted murder. Then they amended the charge sheet to say, we are adding on terrorism. And they still remained on bail. Now this other charge came and it indicated that it also had, the allegations appeared around the same time. August.
The only point there is the second judge have jurisdiction. You don't have to go into all that. The judge have jurisdiction.
The judge had jurisdiction, but exercised it with material irregularity. Exercised it with material irregularity, and that's the reason we are here. Most clarified.
Okay, any response?
Just a few points. Your Lordships,
Your name again for the record?
Joseph Chomhendo, Chief State Attorney. With due respect to my senior land colleague, he has made some misrepresentations to this honorable court. Council, Honorable Kwaku. Your Lordships, the applicants are being detained on 2 separate charges. The first charge being Massacre CRB 605 of 2021, and the second charge being,
What charge is that?
it is murder and terrorism. The second one is Luengo CRB 203 of 2021. Your Lordships, those 2 charges are totally different, separate. The parties are different, save for the 2 applicants who appear in both files. But the parties are different. Yes, the accused persons are different, and the places of commission are different. Luengo CRB was committed from within Luengo district, whereas Massacre CRB 605 was committed from within from within Massacre district. Your Lordships, there is, whereas the applicants are not, Your Lordships, the second one is murder, 1 count of murder. Yes, Your Lordship. Murder, 1 count of murder. On the first, in Massacre 605, there is murder, terrorism, and attempted murder. And Your Lordships, one of the challenges we are facing is the multiplicity of cases. This issue of duplicity is before the Constitutional Court. However, in as much as the parties, the applicants are not the parties in court, but the subject matter is the same. Your Lordships, about a week ago, we were at the War Crimes Division of the High Court in Kololo, arguing and opposing an application by the same applicant.
You are going too far into that. This is the rejoinder, please.
Much obliged, Your Lordship. Your Lordship, it is not true that Justice Toyanze exercised his discretion with material irregularity. He exercised his discretion normally, and the applicants...
They say judiciously.
Judiciously.
Yes.
Much obliged. And the applicants have omitted deliberately to pursue the remedy that is available to them. Where they have filed an application or applications, and the same is not being entertained, Your Lordships, they have a remedy under the Human Rights Enforcement Act.
Either reapply for bail or go under the Human Rights
Enforcement Act. Much obliged. Your Lordships, in further response to Your Lordships, under the enforcement, where an accused person believes that their fundamental rights have been violated, they have a right up to petition court under either Article 50 or under the Human Rights Enforcement Act to petition court, and the remedy that they would have is to nullify their charges. However, they have omitted, or rather they have circumvented all the procedures for this shortcut.
Wouldn't you if you sat in prison for 9 months?
Your Lordship, under Article 134, this appeals lie from the High Court to this Honorable Court, but in accordance with the law. Being in prison for 9 months does not mean that I should abuse the process of court. However long I may stay in prison, I am still mandated to follow the due process of the law.
Very careful with the language. This is the public trial. When you
Much obliged.
abuse, it's not the same thing as using a wrong procedure or going to a wrong forum. It's not necessarily abuse the process. Abuse of process is something specific. So, to be clear, are you talking about abuse of process, or are you talking about being the wrong court or doing the wrong?
Much obliged, using the wrong procedure. Your Lordships, in further reply, it is not true that this court is seized with the jurisdiction to entertain this particular application, because this appeal, because it lacks, we reiterate our earlier submission that it lacks legal basis.
What do you say about Section 130 of the GIA?
Your Lordship, that's where I was coming. Your Lordships, it is a cardinal rule of statutory interpretation that where there are two statutes touching the same matter, the two should be interpreted they should be interpreted mutatis mutandis. And secondly, it is also a cardinal rule of statutory interpretation that the latter statute amends the earlier statute. Your Lordships,
In what circumstances did the statute amend an earlier statute?
sorry?
In what circumstances? Just not amend. If there is someone's wife, why can they be amended?
Your Lordship, Section 36 Section 36 is not in, sections 36 and 35 are not in harmony with of the Criminal Procedure Code, are not in harmony with Section 132 of the Trial and Indictments Act. Your Lordship, since the Criminal Procedure Code is a legislation of 1950 and Trial and Indictments Act is a legislation of 1973, the TIA takes precedence over the CPC. Your Lordships, it is also our submission that there is no special finding. There is nothing like a special finding as alluded to by my land senior colleague, Honorable Kwago. Your Lordships, this is not a matter of constitutional interpretation.
You go back to where the argument started. It goes back to the Constitution, which talks of bail and says this is a special.
Your Lordships, bail, there is a procedure of dealing with bail. I was coming to that, Your Lordship. That whereas the Constitution provides for the right to apply for bail, this procedure is subject to other laws like the like sections 14 and 15 of the Trial and Indictments Act that provide for the circumstances under which bail can be granted or denied. Your Lordships, that section is silent on what happens, or is silent as to where the bail application is denied, whether an accused person has a right to apply for bail. And Your Lordships, it is also our submission that bail, it is silent on whether an accused person has a right to apply, to appeal against a decision of the High Court where the bail application has been denied. Your Lordships, it is furthermore, it is our reply that bail is an interlocutory order or remedy, and if you may allow, Your Lordships, I can read the definition of interlocutory order as
where do you derive that? Just tell, we can look at that.
Oxford Dictionary, Your Lordship.
Which page and which edition?
Much obliged, Your Lordship. Much obliged, Your Lordships. It is also a trial process or procedure begins right from the time an accused person appears in court for either plea or mention of the charges. So any applicant that prosecution commences at a stage where an accused person appears in court for either plea or mention of the charges. Any other aspect, any other application or order made therein before the final determination.
So what do you understand by pre-trial?
Your Lordships, pre-trial means the processes before the actual trial. It is pre-trial is a procedure still within the main trial.
What is pre-trial? What is pre-trial?
Not yet, but they have been committed.
Yeah, but the
So you've
submission.
given us your definition of the trial, that's what we are doing.
Yes, much obliged.
Okay. Summarize, because this is just a guide.
Your Lordships, in reply to my land senior colleague, Council Rakafuzi.
I don't see Ssewanyana. That Ssewanyana was Ssegirinya. Because he must be in court. What has happened?
Could have gone to the toilet.
Yes, we need an explanation. We need to know.
Alan Ssewanyana
Maybe he's not feeling well or something, I don't know. Prison authorities. Yes, come back.
Your Lordships, in reply to my land senior colleague, Council Rakafuzi, it is not true that the applicants were abducted. They were arrested.
Does it make a difference?
Your Lordships, maybe...
Because the method may be the same.
The abduction.
Your Lordships, what... They are in lawful custody. Much obliged.
Much obliged.
That is all from me.
My Lord, I just want to refer this court to something small. From the decision, my lords, that we filed, that is the one of Makumbi Moses versus Uganda, my lords. I would refer you to page 6 of the judgment. My lords, the argument by my senior colleague Elias Lukwago and the Lord Mayor alluded to section 36.
Section
36 of the Criminal Procedure Code Act. As a provision upon which this court can entertain this appeal. My lords, it was clearly stated, and I quote, in that case, on paragraph 20, 20 of page 6. Yeah, there's a paragraph 20 on page 6 of the judgment. Makumbi Moses. Oh, okay. Line 20. That our understanding of the above provision, that is section 36 of the Criminal Procedure Code Act, is that it comes into play only after an appeal is properly before the court. It cannot be a foundation for a right of appeal against an introductory matter.
Yeah, and they don't say this is an interlocutory matter. That has been the argument all along. That this is not an interlocutory, is not an interlocutory matter. Should have been addressing it in that light.
Most obliged, my lord. My lord, we take our submission that this was an introductory matter and not separate.
Okay, thank you.
Most obliged. That's all.
Council, thank you for your very extensive submissions and the authorities you reported. You are raising matters that need to be looked into much more closely than meets the eye. We therefore request for time, that we get time and come up with a ruling that will cover all the matters you have raised. So we adjourn this matter for a ruling to be delivered on the 29th of June 2022. That is Wednesday next week. This is the Court of Appeal of Uganda. If you want to go there, you go there. We are going to be here. This is why.
My lord, this is okay. My lord, my prayer is only one. Those people need medical treatment.
They need what?
Medical treatment. Can they be out till 29th?
This is the bail application is going to be here. So I will be again the circumvent that. Let's handle first things first. Yes, I see the hands of both Ssegirinya and Ssewanyana, Honorable Ssegirinya. Can we start with the Honorable Ssewanyana? Please rise and tell us what you want to say.
Thank you, Your Lordships. First of all, I apologize for leaving court without applying for you. I wasn't feeling well. I thought that I could go out and vomit a bit. Your Lordships, we are very sick here in Chico Prison. We have complained about it for several times. It is now 9 months complaining about the same. Lower courts and other courts so that there has to be given more female employees of party special medical attention. Up to now, we have not yet got it. Your Lordships, we have children to look after. We have constituencies to look after to represent in Parliament. We have projects that have stalled for more than 9 months now that are waiting for justice to prevail. And through you, Your Lordships, if you help us and grant us a new way and leave prison, make a temporary freedom for all that one us gets treatment, at least reach that day when the trial commence, when we are faced with a trial, Your Lordship. We were tortured when we are arrested. We have complained about this for several times, but as the state has denied several times. But we know that in front of you, we can get that justice that we came for. I so pray, my Lordships.
Thank you.
My Lord, thank you so much for this opportunity. It's quite absurd that the state is using remand as a punishment, and it's in the Ugandan Constitution that remand should not be used as a punishment. My Lord, I was kidnapped at the entrance of Chico Prison the day I was released. I was tortured, but after today I never received any medication. My Lord, our reply that it is just for today so that you can go and get better medication. Thank you. That's my prayer, my Lord.
Yes. Yeah. Both of you. Both of you, we are sorry if you are tortured. Torture is not allowed in this country. It's outlawed. It's a serious matter, and the court takes it seriously too. So if anybody tortures, it's against the law, and the court cannot allow that. For treatment, the court law had ordered that you be accorded treatment in a place which fits your ailment. And we reiterate that the prison authorities should where you are ailing should give you appropriate treatment. The application before us is for bail. So we are going to hear the application if we allow this. If we don't allow this preliminary objection. There is an objection raised that this application should not be heard by this court. And that's what we have been hearing since morning. We are going to determine that and see whether the bail application is heard or not. And depending on the result of this preliminary objection, we then decide how to handle the matter. So the matters you raised, both of you, regarding your constituencies, your children, your sicknesses, and so on, if the bail application is allowed to be heard, will be addressed in the hearing of that application.
Maybe a question. Can you be clear? Are you saying that the treatment you're getting in hospital, in prison, is not sufficient? Because we are aware that the prison provides, specialists who visit and they assist you. You are not specific. Because the court is right, he said the court is not adverse to your opinion, your health. Did you hear what I said?
Yes. Yeah, we have always complained about it, your lordships. We have ailments that cannot be handled within the prisons, heart attack, and others of hypertension, and others that we suffered when mishandled at the day when we are rearrested. Some of our private parts are not well. We believe that if given that chance and go out, we can have our lives made better by special physiologists, and we will thank God for that. That's what we are meaning. But for malaria, there is treatment, and cough, there is treatment, but those are not the sicknesses that we are talking about. We are talking about ailments that need special attention. As you will hear, if you grant us that chance of hearing our bail, you will hear from the presentation of our lawyers and us on that day. I thank you, my lordships.
Yes, you raised an important issue of ailments touching on your private parts and so on and so on. Did I hear you well? Ssewanyana, did I hear you well?
Yes, you heard me well, your lordship. Only that the internet is disturbing us a bit.
So, then which facility in Uganda would you want to go to handle that? Are you saying you should? Because you have not mentioned that we should be taken to Mulago, because Mulago is the preferred hospital in this country. Should the prison authority take you to Mulago for treatment or something like that?
We have always cried for such, but they have not, my lordship.
Okay. We note that, and we are asking and directing the prison authorities to ensure that you get treatment which will be able to handle your ailments in this country.
Do you have anyone in prisons here?
Do you have a prison officer? In the
Do you have some?
yeah, they are there.
The services to check this man to a referral hospital, Mulago referral hospital.
Can you say your name and your rank and what you want to say?
Doctor, I'm number 15722, Ward Ronald, working with the Uganda Prison Service, specifically at Chico Main Prison. My Lord, as far as the medical issue is concerned, our medical team is handling it very well, and I am convinced in case they need to be referred the National Referral Hospital, which is Mulago, our medical team can every do that, my Lord.
Is it being done? The question is it being done?
The condition is not bad, my Lord.
Take away your good.
Obviously that my Lord is not competent. said
It
anything.
is a statement, it's not a doctor.
Yes.
He's just saying they are being looked after and they are getting medical attention.
This
Now,
is
what
well.
is saying he uses a specialized. And we are asking the prison authorities that please ensure that they get appropriate medical attention, including if it is necessary to take them to a specialist or to Mulago Hospital where we have all these specialists.
Okay. Much of like in my road, we are going to ensure that that directive is handled, is taken into consideration.
For the record, my lord, for most of them.
Just a minute.
Most of them.
Your prison officer, yes, you have made your statement, but the person who is sick is near you there. And he says he's not feeling well. And he has just gone out to vomit and come back. I'm sure you saw that, you must have followed him. So the ailment is there. I think it is important that we set timelines how you have these people treated by people competent to treat their ailments. Can we then say that maybe every 7 days we call a specialist, and if they are not able to come, we take them to a specialist. All these specialists are in Mulago Hospital. Either you bring them to the prison people or you take them there and they get that attention. Before we come back here, we are going to be here next Wednesday. So they should be treated before that day.
The specialists should know whether they need to file or not.
Okay? Is it clear? Prison officer, is it clear? Have you heard?
I don't, you're not clear, the microphone is not so clear.
But you have heard that we want them to be taken all especially considered before we come back here next Wednesday.
Thank you so much. We are going to communicate with specialists in my room.
Council, area of Lupago, do you have anything we think we don't have any right of reply?
It's not a reply, my lord.
Yes.
It was in regard to that issue.
Yes.
My lord, they have previous orders that have been given, that they have always been defied, that they be taken from examination. And not calling in the physician because the physician will not come with the equipment. Say, for example, they need a scan or MRI or whatever.
That will be decided by the doctors. They know what is needed and where it should be done.
Most of that.
And those orders were not given by the Court of Appeal. These are orders of this court, the prison authority.
Most of that, my lord. Just for the record, my lord.
Okay.
Just the person who wants that. On that day,
Okay, thank you.
yes. On 29th, I will not be here, but my colleagues.
That is another matter. We have not reached there. Don't cross. We have finished. The court has finished that matter. And so,
Just informing you.
if that day you are not here, whoever will be representing them will stop.
I just wanted to be on record that I'll be out of the country, my lord.
No, we can't put that on record because that file is closed. You know.
Most of that, my colleagues will be here.
Yeah.
Most of that.
Okay.
Ampuliriza ku KI omulungi, ampuliriza mwanyinaze omulungi. Luli network yatucyankalanyeko, data yatucyankalanyeko, kyobola banga navuddeko kati nkomyewo. Tuli live mu kooti. Bambi kyensaba obanga otowulira kibi kyonna osobola okgenda ku YouTube n'olabira eyo. We are live ku YouTube.
Webale kulaba Kk Tv Uganda. Get informed and updated on issues around you and the globe as well. KK TV. Thank you for subscribing to KK TV. Webale kulaba KK TV Uganda. The inspiration and the best broadcasting around town. KK TV. The global experience, the might, the power, and all you need with KK TV. We are your broadcasting experience. Thank you for subscribing to KK TV.
Museveni eranga bwe yakyogedde yayogera n'abantu abalala neffe tetulina kye twogera naye kuba aliwo mu bumenyi bw'amateeka. Ekyokubiri tetwetaaga kwogera naye kuba obuyinza si bubwe, obuyinza bwa bannayuganda. So tetwetaaga kwogera na Mwai Museveni. Ye okwogera n'abantu tayogera ku ngeri ggwanga gye likyuka naye abeera ayagala kwogera naawe kubuuza oyagala ssente meka. Ffe tetugulirirwa.
Bakikola okulabisa okulaga nti tolina kyoli.
You are watching KK TV.
Kikulaga nti eno gavumenti ya Museveni eriwo mu bumenyi bw'amateeka, tegondera amateeka, tegoberera amateeka, yo ekola byeyagala. Omuntu omu yasalawo, basalawo nti kati beera mulamu ng'obeera mulamu, wasalawo nti kati beera mufu ng'obeera mufu.
Mr. Update Kanumbe, oba bankuba bankube, oba banzita banzite, oba kyekigwawo kigwewo.
You are watching KK TV. Webale kulaba KK TV Uganda.